My lords, 3 new pieces of paper for you. One is my learned friend's written version of the concession report.
Very helpful.
One is a further short extract from the Law Commission report on the Section 10 point, which I'm just saying out of convenience now, but I'll address in about half an hour's time, I'm guessing. And the last is the letter that you asked for.
Yeah, okay, right.
And just so you know, the bits that I was either actually or implicitly citing are on page 1, the second substantial paragraph. The Minister considers it not desirable for civil service employers to provide an unnecessary service on behalf of trade unions. And you'll see the next paragraph attached is guidance. And then over the page, under background, many departments provide a service to trade unions whereby trade union subscriptions are deducted, voters check off. The use of check off varies considerably based on data provided by departments. Some unions are significant beneficiaries from the service. So the short point was that everybody, not just the union side, but also the government side, saw this as a term, if not solely, at least primarily for the benefit of the trade unions.
Where's the bit about, or is it not in this letter? I can't now remember what the phrase is, but unions which were not always aligned with our interests, or whatever the phrase was. I haven't made that up, have I?
No, it's there.
Is it there? Have I got
Not there, no, it's somewhere.
I will get those behind me busy on that.
So it doesn't look as though it's in this letter.
I
Okay.
don't believe it is.
It is in the bundle because I've seen it.
Yes,
and not on a train. I mean,
Well, I'll tell you. Well, no, I'll tell you one problem. We've got only pages 1, 3, and 4 here. It might be on page 2, mightn't it?
so,
Well, there we are.
Right.
That will
This
be
is the
sorted out.
third time you've caught me out at not noticing a document not complete in one day. No, I hadn't.
Which reminds me, have we got to the end of not having the full defence in Smith?
My lord, I don't know why it's not in there, but what I
Yes, I know, but I mean, I assume
the
somebody would get it for us.
But the answer to your primary question, which is to do with, is it signed by council?
No, that wasn't really my question. That was only why. That was what I was. I'm sure it may or may not be. But I just wanted to make sure we got the whole thing.
Then we'll make sure you get the whole thing.
Yeah.
But we don't have it with us now.
Thank you. So what the answer is, it was signed by council.
No, it wasn't. None of the pleadings were signed by council, but they were pleaded by council. They were drafted by council.
Yeah, but both, was it just an accident, or has something happened in pleading practice since I
don't know why it didn't happen in this case.
Yes.
Ordinarily, I think pleadings
On
do
both
have council's
sides,
name.
pleadings
No,
signed by council.
I believe ours was. It's just not in there. But certainly, I don't know of any change in the practice. That
No, well, that's fine.
Council should sign.
My lord, I'm told there is no final page. That's
Oh, I see. So we have got the whole thing.
You
It
do
just
have the whole
stopped.
thing. It did just stop.
gosh, what a weird world we live in now. Even nostalgia's not like it used to be.
You're absolutely sure that's right, are you? Just
My
but wouldn't there be a bit at the end? It's only signed by. If it's not signed by council, there must be a page where it's signed by the solicitors.
I think there was an issue around signing, and then there was an amended defence put in where
Okay,
there was.
I'm not going to pursue it any further. It's just an oddity. Okay, thanks. Thank you for all that.
Right, conscious that the whole issue was probably sorted out in 2 minutes after we adjourned, I'll try to address the various thoughts, questions, and reflections. And as I say, in nearly every respect, I was due to. So we do start from the proposition, and I put it as high as we advance it, that the fact that entitlement to check off did likely derive from a historical collective agreement is not relevant in seeking to infer the intention of the parties to the employment contracts made several decades later when the Act was in force. And I'll try and make that good. The first point is one that I did allude to briefly before the adjournment, that the legal status of the presumed collective agreement can only be relevant, certainly as a matter of strict contract law, to inferring the intentions of the parties to the later contracts of employment, insofar as it was part of the background circumstances or matrix of fact known or assumed at the time they entered the employment contracts. Now, I accept that in this case, that may give rise to the potential for different answers in different individual cases, but you are dealing in the main, and increasingly, with people who are joining the civil service after the 11th of May 2000, and obviously by now, probably, and certainly if not by now, very shortly, you will have no one who was there when the collective agreement was made, and almost no one within 10 or 20 years who was there before the Act was in force. And it would be a little odd if there was a sort of sliding scale of presumed intention as time ticked on.
Yes, but what gives rise to this presumed intention is not the 1999 Act, which nobody will be familiar with, but the culture of a presumed objective employee about whether rights accorded by an employer to a trade union, or benefits to a trade union, are enforceable by the trade union.
Well, but with respect, I don't think you can divorce that question from the coming into force of the Act, because before the Act came into force, it's a non-question.
But if every overstating the case, I'm sure, but if every employee knows that collective benefits between employer and employee are not enforceable, it doesn't matter whether that started in 1960, it's still the case now. If everybody knows that, that will be relevant to construing their intentions when they enter a contract which purports to confer a benefit on a trade union of a collective character.
Well, my lord, I would respectfully suggest, I realise you're just putting a proposition, as it were, for me to consider, but I would suggest that's a viciously circular argument, because until the 11th of May 2000, no one has any intention. I mean, I'll take it slightly out of order, but one of the points I was going to make is that if the appellant's argument is correct, any contract, as I see it anyway, any contract made after May 2000 where the material term was first agreed before that date would not fall within the scope, and by fall within the scope I mean be enforceable by the third party, because it could safely be stated that the parties who originally agreed that term, and that could be the original two parties, not the third party, so it could be A and B, not A and C, whether A and B or A and C, when they agreed it, of course they would not have intended, and one could easily construe, if one was simply to appeal to the background matrix of fact, and I'll be saying that that's not actually what we should be appealing to, but running with it for the moment. If that's what we're appealing to, then you will always have been able to infer an intention that the term should not be enforceable by a third party, because there was no legal mechanism for that to happen.
Yes, but that's the reason why there was no legal mechanism is not because of the privity law. The point that creates the difficulty is the lack of intention, going back to the Donovan inquiry, that law enters into collective relations between trade unions and employers.
Yes, but that only provides for, in this context, the universal case before 2000. That law that my lord refers to, that was first part of the common law and then part of statute law, was to negate the exception to the rule. That's a double negative, I understand. It wasn't to create an exception to the rule. So, in terms of, I'm talking about in terms of third-party enforcement, obviously. So, you have a collective agreement, and forgive me if I'm going back too much the basics here. I realise that probably all, and certainly just Underhill, will know this all too well. But collective agreements are generally not made about one thing. They don't usually have one term. And in the public sector, collective agreements are not untypically hundreds of pages long. And it is inconceivable that in this case, and we're all just dealing with the balance of probabilities because we don't actually have the collective agreement in question, but it is inconceivable in this case that there was ever a collective agreement entitled the right to check off. Rather, there was a single large, or possibly two or three large complex collective agreements, one of which included the right to check off. But it included...
Or more likely, another possibility, frankly, how these things are, if you go back far enough, what you actually had was minutes of joint negotiating committees, which from time to time would produce another agreement, which would then be written down somewhere. That's how it was done in the coal industry, which was then, of course, a publicly owned
Yes, you aggregate over time, I accept, things that are discussed at one moment in time into either an existing agreement or a new agreement. But those agreements will have within them a multiplicity of terms, some of which the parties will know will form part of individual contracts of employment, pay, to take the most obvious example. Others of which they will know are not going to form part of contracts of employment. The dispute resolution mechanism between the employer and the union, for instance.
Or the provision of office space for the union in government premises.
Facility time, the notice provision, giving notice of termination, for instance. So you have these large collective agreements that have a huge number of terms usually. I'm not saying which is the majority, but a large number on each side of the line to be incorporated and not to be incorporated. All that the law presumed and then, as a result of statute, demanded was that the collective parties were not able to enforce any part of that collective agreement against each other. For obvious reasons, nearly in every case, not in every case, but in nearly every case, the union and the employer did not negative that common law then statutory presumption. Because, well, I don't have to explain why a union wouldn't want to be in a position where an employer could sue it. That has absolutely no bearing, we say, on whether, as to an individual term to be incorporated into a contract of employment, if either at the time, which is counterfactual, I realise, there had been something the equivalent of the 99 Act, still less if at some future time there were to come into existence the 99 Act, that individually incorporated entitlement, which confers the benefit, if not only, at least primarily, on the union, should not be enforceable by the union. There is a just complete disconnect.
Well, I'm not sure.
There is, I mean, I haven't been on a train, so I haven't thought this one through yet. I'll have to go on the circle line. But prior to 2001, the union would not have been able to get the facility. And I use that phrase very loosely. Why? Because as far as the contract of employment is concerned, there's no legal mechanism pre the 99 Act by which third parties could enforce it.
Yes.
The assumption was that unions wouldn't be able to enforce their own agreements with the government because they were not legally enforceable agreements. But also, there was no way in which the culture was to have the union made a party to the contract of employment for the purposes of enforcing collective benefits rather than just individual benefits. They were totally outside the scheme of legal enforceability, even though there were two routes available and one route wasn't available. And the question that's puzzling me then is, when you go post-2001, and if one is right to look at 1B and 2 together and say there is a collective benefit, is the underlying assumption for that collective benefit that the parties intended it to be legally enforceable by the third party or not? Is there something about the nature of collective benefits that the union want to get which makes it likely that the contracting parties would say, no, that's outside the field of what we would normally intend. There is a mechanism now, but just as we didn't intend it before, because there was no mechanism, and we didn't have a situation where the unions could enforce it themselves, and we didn't make them part of our contracts for the collective benefits, because all of that is outside the realm of legal enforceability. I wonder whether that's a correct analysis or not. But you say no, obviously.
I do say no.
We have to, really. I mean,
But I think there are two. Well, there are three problems I have with it.
yeah.
The first is an overarching issue, which I know I want to come back to as flagged by Justice Stuart-Smith, which is what do we actually, let's go back to the statutory words in section 1.2. What is the test? Mm-hmm. The test is the proper construction of the contract.
Well, it's 1B and 2, yes.
But I'll come back to that. The second is what one means by culture. And the third, and I realise you caught yourself in the slip of the tongue, as it were, about the intention not to or not to intend to.
Yeah.
But can one not intend an impossibility? What we're asking ourselves here is whether there was an intention that the term of the contract of employment could be enforced. Yeah. Now, it is right to say, using the wrong formulation, statutory formulation, there was no intention that it could be enforced, just as there can be no intention that the sun will rise in the west. That is a quite different thing from saying that there was an intention that it should not be enforceable. You will all no doubt remember these cases much better than I, but there are cases I remember studying back in the day where, as it were, the advent of technology had to be accommodated within a contractual framework where the original contract was made before the invention of the telex or the fax machine or whatever it might be. And it is not the case that when something new happens, you are forced, as a matter of contractual construction, to assume that the parties could not have intended, were it to happen, that it should not be given effect within the contractual framework. So here, what you had is the collective parties saying that the collective agreement, not the contract of employment, the collective agreement as a whole, not this particular term, was not enforceable. So you have no intention that it should be enforceable as part of that collective agreement. That's the only cultural issue here. There was never a cultural intention, habit, presumption about whether or not the term of the contract of employment should be enforced by PC. Well,
I don't think that's the case against you, though.
Well,
it's the fact that there is no intention that it should be enforceable by the union at the collective level is a strong indication the parties didn't intend that the same obligation, substantively, should be enforced at the individual level.
Well, my lord,
that's the way.
That's the appellant's case, but asserting it, with respect, doesn't, I would say, assist the court other than accompanied by some explanation of what, on its face, is a non sequitur.
Well, it doesn't seem to me like a non sequitur.
Well,
seriously, what we are concerned about as a matter of substance is whether the union has a legal right to enforce or to claim damages for breach of an obligation of, assume for the moment this is a fair characterization, a collective obligation or a promise of a collective character. Now, that is what the case is that people would not expect to be the case. So I put that rather badly. It doesn't matter by what route it wouldn't be enforceable, whether by enforceability of the parent collective agreement or by the enforceability, once this became a possibility, of the individual contract of employment which referred to it. Either way, the union couldn't sue. And if the real point is, can the union sue, it doesn't seem to me to be a non sequitur to say that because the union can't sue at a collective level, there's no reason to, it's unlikely that it was ever intended to sue by a different route.
Well, I mean, there comes a point where I just have respectfully to disagree.
No, well, due with great respect,
I mean,
Mr. Steve. I'm putting points to you rather than expressing
of course,
a
my
concluded
lord,
view.
I genuinely appreciate it. Take the paradigm case. There'd always been a 99 Act, only it was a 1799 Act, not a 1999 Act. And there'd always been a presumption against collective enforcement of a collective agreement. I struggle to see why, in that situation, where a trade union sits down with an employer and agrees a term that everybody knows is going to be incorporated into every contract of employment, that everybody knows confers a benefit on the trade union, and that everybody knows there's this legislation in place which says if a term is conferred on a third party, you can sue on it unless there's a way of properly construing the contract so that you can't. Why should, in that situation?
Yeah, it is critical to your case. I mean, the fact that the Act came into effect is critical to the thing that stopped the union getting the benefit of a collective type of clause before was the absence of a mechanism, and that has gone. And you say we should not go beyond that. We don't need to go beyond the collective agreement not being enforceable. So what? It's not the agreement that's
Well,
the issue.
exactly. But I do think it's worth. I know it's counterfactual, but I think if the answer to my counterfactual hypothesis is in that situation there is no basis for properly construing the contract of employment so as to exclude that right, a fortiori there can't be one if the thing hasn't even been conceived.
That is your point. The whole landscape, the only reason why unions couldn't get it before was nothing to do with the industrial landscape at the collective level. It was the absence of a mechanism. Yeah. And that has gone, and then we apply the words.
Well, that's my first big point, so I've still to come on to the second, which is what proper construction of a contract means, because it seems that we may be at odds on that. But
just before you get there, can I just ask this point? It seems to me that your point on this would be stronger. Well, let me say even stronger. if
I was hoping
if the facility which the employer promises the employee it will afford to the union only benefited the union. We all agree it benefits the union. I think we tend to agree that it primarily benefits the union, but it is not of no interest to the employee. The employee also likes it because it's more convenient.
Yes, I mean, I would find it hard to conceive of a term that, within the scope of the Act, that didn't benefit the promisee to some extent, even if it's only for administrative convenience, as it were. We'll pay
fair point.
the person that you have to pay, which is, after all, the situation. But I'll live with even stronger. I mean, can I just, as it were, before I turn to the construction of contract point, can I borrow something that will be relevant to the Section 10 point? I've passed up the Law Commission report at paragraph 1420. I realise I'm at first blush straying into a different area of submission, but I promise I'll circle back. So the provision was included, as you will see, to avoid the Act having retroactive effect and to allow a reasonable period of time for professionals and the public to become familiar with it and to redraft contracts if appropriate. Now, employment contracts, as we know, tend to be longer-term relational contracts, which notoriously, we also know, involve an inequality of bargaining power. Those are features they do not share with most commercial contracts. So it is, putting at its lowest, arguable, putting it slightly higher, to be expected that employers would amend contracts in the wake of the passage of the 99 Act, less probably to remove terms which confer benefits on third parties, much more simply to put in a statement. The third party's contracts of the third party rights of the contracts rights of third parties act is excluded. That's all they needed to do. And if they don't do that,
then they live with the consequences.
they
live with the consequences.
live with the consequence. So
And you can follow it through, because one can imagine circumstances where, if, assuming the government knows the legislation it has just passed, and that it's based upon this Law Commission report, they say, right, we're going to impose that term, there may be kickback. And if there's kickback, what just goes down here, one can well imagine there could be kickback, because the employee's side may say, not a bit of it, this is something where we absolutely want the union to have.
yeah.
And so on that basis, all one can deduce from the absence of any action on either side, the fact that there's nothing in the contract at all, is that there was not agreement one way or the other, in which case there's no contrary intention.
Exactly. But I do want, because I realise that there is still a potential gap between the way that certainly Lord Justice Underhill and I approach the potential relevance, whether it's determinative or not, another issue, but potential relevance of the intention of the collective parties. And we do say, and I know you've been taken to it, and it's very short, but we do say that the editors of Harvey's get it right in A257. I must confess, I thought this was uncontroversial.
Didn't disagree.
So is this?
We didn't disagree with it. We said that it wasn't wrongly applied in the case.
You're both ahead of me, so haven't you got the passage we're talking
257 in the authorities bundle, and I take on board what my learned friend helpers said.
Yes, what?
So once incorporated into an individual contract of employment, a provision which owes its origin to a collective agreement falls to be construed strictly in accordance with the rules of construction. This takes us towards the proper construction of the contract point, applicable to contracts. In consequence, evidence may not be adduced as to what the parties to the collective agreement actually meant at the time of agreeing the collective term, which has become imported into the individual contract of employment. Stop there. I accept Hooper doesn't assist the court. That's relied on really by the editors of Harvey's in respect of what follows in that paragraph, the subsequent.
Well, can I just be clear about that? Because you basically are you saying that the proposition in para 62 is not supported by Hooper? Or at any rate, the first
I thought
half
Mr. Sheldon said that was accepted as, that paragraph 62 was accepted as an accurate statement of the law, although he didn't accept Hooper was relevant. Did I misunderstand that?
That is what I think.
No, but that is what I said.
Yeah.
But it's not relevant to the analysis. Yes.
So we say, and it's now common ground, sorry, perhaps it was always common ground and I misunderstood the decision, that is orthodox. You don't need Hooper to
Well, what is orthodox?
The bit I just read out, that once incorporated into an individual contract of employment, a provision which owes its origin to a collective agreement, so that's this case, falls to be construed in accordance with the rules of construction applicable to the contract.
Well, that's fine. That's obvious.
Well,
But it's the inconsequence that doesn't follow.
well, that's also part of what I thought was now common ground. In consequence, evidence may not be adduced as to what the parties to the collective agreement actually meant.
Yeah, I see, but that's the point, is what they actually meant. It's basically just saying the rules against subjective interpretation, against trying to ascertain the subjective meaning of the parties at the time of negotiation apply just as much in this context as they do in ordinary contractual contexts. That is what Hooper decided. And in my view, what's happened is that the proposition in Hooper has been stated arguably a little too widely in 62, because they weren't having our point in mind at all.
Yes, I'm prepared to delete the reference to Hooper and withdraw any reliance on it. But where I apprehend now that the more nuanced difference perhaps between certainly the parties and perhaps between myself and what my Lord has just said, is in the proper interpretation of the words actually meant.
Well, look, can we see why this actually potentially matters? Clearly, the subjective intention of the union negotiators of a collective term that's subsequently incorporated is irrelevant, just as the subjective intention of the individual employees would be irrelevant. But if you are trying to look at the factual matrix as known to the parties with a collective term of this sort, the real question is, are you allowed to look at the factual matrix as known to the union negotiators, though not to the individual? Or have you got to look at what the individual would know? And my provisional view at the moment is that in a term of that character, the relevant factual matrix is material known to the parties who actually made the contract. That is to say, the union negotiators who made the contract is the wrong word, who actually negotiated the term, namely the union negotiators and the employer. Now, you may say I'm wrong about that.
No. I think, if I may, I think this doesn't sound too silly. We're both right. I think if you're looking to understand what a term means, so like in the Hooper case, as I recall, the term said you're entitled to indefinite sick pay. The evidence was we never meant to give you indefinite sick pay, so you shouldn't have it.
Yeah.
That was part one of the argument. Part two was, and we didn't do it, so with the subsequent period. I accept that when you are trying to understand what the words mean, when you are, and I use the word colloquially, not colloquially, but not in its strict sense, when you are trying perhaps to rectify a term, then yes, my lord, what you're saying must be right. That it's the parties who used those words.
Yeah. Okay. Well, that's fine. That's
party, but that's not what we're talking about here. We're talking about the construction of a contract made between employees and employer with a view to ascertaining the intention of the employees and employer. And I thought we'd all agreed yesterday that what a party means by something and what a party intends by something are just two ways of saying the same thing.
Yes.
So in that context, I say, no, you're not looking at the matrix of fact known to the union in 1950 or whatever it was and known to the employer in 1950. Not that, incidentally, I would say that our argument is vitiated one jot if you were, but that's not what you're looking to.
But if it sorry,
No.
I'm interrupting.
No,
If
you haven't.
if you were right that although it's a contract between the employee and the employer, the relevant people are the union and the employer.
Only in terms of what the words mean.
If it were right, you'd still have the problem, wouldn't you, of providing a logical justification for assuming that once it shifts from the unenforceable collective sphere into the sphere of an enforceable contract, of deducing or assuming that both sides would agree, oh no, of course it's not enforceable in the context of a contract.
We're both itching to get to the same point, I can feel. But if I would agree, as long as by you mean they would have the problem. Yes, absolutely. So for a split second, I thought this was going in a direction I didn't want.
Personally, Mr. Sheldon.
Not taken personally.
So that's what we say is the non-relevance, or perhaps, if you wish, the exceptionally limited relevance of what happened in 1960, whenever it was. To recap, the presumed unenforceable status of the historic collective agreement as a whole sheds no light on whether, had the 99 Act been enforced at the time, still more, were it to come into force, that even the parties to the collective agreement would have intended that once incorporated as a term of individual contracts of employment, check-off term should be enforceable. And I now want to turn to what, in a sense, should have been my point of embarkation, but because I wanted to deal with the employment aspect and the collective aspect first, I've rather abandoned what we really all should be focusing on, which is the words of section 1(2). And what does it mean to construe a contract? And what are we construing here? This is a fairly odd case, really, in which my learned friends are asking you to construe something. They're not actually telling you what you're construing. There is only one potentially relevant term of this contract. Everybody agrees that. That is the entitlement to check off. The contractual entitlement each employee has to the check off facility in respect of, for these people, PCS, which we know confers an obvious benefit on PCS. Now, it's so obvious that perhaps I haven't made it sufficiently clear, but there's obviously nothing in that term that begins to enable us to construe properly this contract so as to negative the presumption in section 1.
No, but you do get cases, don't you, where a term literally is perfectly clear what it means. But when read with the eyes of people experienced in that, this is all, contract week 1 stuff, period parties experienced in that field, they know that when they say black, they actually mean grey, or when they say 12, they mean 13, because that's how everyone understands the situation there. So, and that's an extreme form of looking at the factual matrix.
No, but
and that is still construction of the contract, even though the contract unquestionably says 12.
But my lord, I don't depart from that at all. That is to construe the words to give them their proper meaning as opposed to their apparent meaning. And as you say, that is week 1 of contract law. That's not what we're about here. There is no word in that term that adverts to enforceability by PCS, never mind seems to say one thing or the other. What you're actually having to do, being asked to do by the appellant, is imply a term into the contract that qualifies the term you've got to the effect that the employee and employer intend the entitlement to check off not to be enforceable by PCS. That's what you're being asked to do.
Says it again, imply a term that...
You're being asked to imply a term into a contract of employment, which is perfectly...
No, what does the term say?
Well,
imply a term that qualifies...
That qualifies the... Or maybe qualifies isn't the right word. Supplements may be a better word. Supplements or qualifies the term you do have, that the employee has a contractual entitlement to a check-off facility, with words such as, but that is not enforceable by the trade union.
Yeah.
And I'm not dissenting for a moment that you can imply into contracts of employment qualificatory terms. It's done all the time. But there are very clear tests for them, and they're no different in contracts of employment than any other contract.
Yeah.
And the only basis that has been advanced for implying that term into this contract is that at a time before the Act was enforced, sometime around 1960, the relevant unions didn't agree with the government that the collective agreement in which check-off entitlement is presumed to have been included was enforceable at the collective level. That's no basis for implying a term. Which test of implication, which legal test would the appellant say is met by that part of a factual matrix? It's obviously not that to imply such a term is reasonably necessary or to give effect.
Too obvious needs stating.
Yeah. Well,
but you may say it's not too obvious needs stating, but that would be the correct route.
I accept. If
and I think that is the case against you. The case against you is it's too obvious, given what everyone understands about the enforceability of collective rights. It was too obvious to need stating that this right you're giving to the individual couldn't be enforced by the union. Maybe right, maybe wrong, but I don't think it's intellectually incoherent.
No, I agree with you. I agree with my lord. It is not intellectually incoherent. The reason I made that gesture was because it seems to me it is an impossibly high bar to even sensibly posit, let alone surmount.
I just wonder whether it is implying a term. I just wonder whether 1A, 1B and 2 have to be read together. And reading them together, they mean something like, if the contract term appears to give a benefit to a third party, is there anything on a proper construction of the contract to say, no, it wasn't meant to be enforceable by the third party? And whether the fact that unions aren't normally entitled to enforce provisions is enough or is not enough.
I think for the first time I may depart from the construction. I mean, we start with subsection 1 subsection 1, my apologies. Subject to the provisions of this Act, a person who is not a party to a contract may enforce if B, subject to subsection 2, the term...
Two things. It's important to one is important. A person who's not a party to a contract may in his own right enforce the term if one of two circumstances are there. The contract expressly provides that he may. That means that there's something in the words of the contract that includes it. And then B, the term doesn't confer a benefit on him, but purports to confer a benefit on him. And I'm still obsessed by what we read this morning, that's some sort of convoluted shorthand for is intended to enforce a benefit, intended to enable him to enforce the benefit, even though it doesn't say so expressly.
Yes, I thought that we had agreed, but certainly this is my case, that purport to is effectively a tautology for subject to subsection 2.
Sorry, I just misheard that. Purports to is effectively, then what did you say?
Tautology or subject to subsection 2. So in other words, because you can't say it does confer a benefit until you've decided whether subsection 2 applies, prima facie it only purports to. It may end up conferring.
But the thing then is, what is critical is not the factual. The third party would benefit if it could enforce it. What is important is, because there is a situation of benefit, you'll assume the intention of the parties to the contract is the third party can enforce it, just as he could in A if it was expressly said to be so. And then when you're looking at 2, it's not quite are there words in the contract that says, no, you can't enforce it. You're looking for something that appears to suggest, no, even though a benefit is going to be enjoyed by the third party or is contemplated as being enjoyed by a third party, that isn't of itself equivalent to it being intended by the contracting party that it was going to be enjoyed by it. And the thing is that
it's the rebuttable
what it
presumption.
said then is that nobody expects unions to be able to go to court to enforce provisions, whether it's in the collective agreement or whether it's been translated into the contractual agreement between the employer and the employee.
Yes, but two things. First, subsection 2 is the rebuttable presumption, to use the Law Commission phrase. The presumption can be rebutted expressly or implicitly. Yeah.
But what is the presumption?
The presumption is it's enforceable.
No, the presumption is that the parties intend the benefit to be enforceable, the term to be enforceable.
Well, I guess one could put it either way, but the strict language is it is enforceable unless. Right. So if you tick box sub 1 and sub 1b, then you are in unless, on a proper construction of the contract, it appears that the parties did not intend the term. The second rebuttable presumption, if you will, is that because the formulation appears that the parties did not intend, that you have to show the onus of proof is that they do intend. So I would say, in the sense that they're two parts of the same picture. And now I've forgotten the point.
Well, then the next question is,
yes, the union. Yeah.
If the context is that unions are not expected to go to courts of law and enforce contract provisions, and that's the thing, I'm genuinely trying to work this out, that is the thing that shows the parties did not intend to be enforceable. Yes, there's a benefit on a third party. Everyone thinks, well, yes, of course, if they give them the benefit to a third party, you can go off and sue. What makes it different here? Well, no, nobody expects unions to be able to sue because unions don't go to court because of all of our history relations.
I think this is a situation which hadn't arisen before.
Well, that's Mr. Seeger's
But also,
critical point.
I think my lord, wittingly or unwittingly, I don't know,
Well, I'm only trying to
made
help.
an important but made an important or used language and in a significant way when you posited that unions, I can't remember the exact words, but I remember the important word. Unions are not expected to enforce terms of contracts.
Yeah, and not intended to enforce terms of
Usually,
contract.
terms of contracts. No.
Terms of collective agreements.
Terms of collective agreements. Collective agreements are not contracts
Yes, I
unless
agree.
expressed to be
Well,
so.
they are
That's the
contracts,
point.
but they're unenforceable.
Well, I bow. I mean, I defer to
Well, all right.
higher level
Agreements,
analysis, my lord. But they're agreements. My understanding is a contract.
Yeah, you're probably right. You're probably right. But we're playing with words here, aren't we? We've got to look at the substance of the case you're meeting on this, which is that in the case of a provision in an individual contract, which purports to confer a benefit, does confer a benefit, which obliges the employer to confer a benefit on the trade union, the cultural and historical background against which unions don't have legal enforceable rights for collective benefits of that kind, means that or is a sufficient indication that the parties to the individual contract didn't intend they would have it in that context either.
But my lord, it seems to me that one is saying, to put it boldly, that because there's a culture that unions don't eat apples, one should infer there's a culture they don't eat pears.
Well,
why
is there a
because
difference?
the apple is in the contract. It's the same thing.
Yes.
It's the same fruit.
The apple is the
Contract.
facility.
Well, I don't want to get lost in an over sophisticated fruit analogy, but the what you are enforcing in the contract of employment is not the same beast.
It is not the legally
As
same
Moving
Moving from
fruits
one
to
metaphor
beast.
to another.
But it is the same. But it is the same beast, or it is the same fruit. It is a check-off facility, and it's a check-off facility whether it's afforded to the employee or whether it's afforded to the union.
The union is enforcing the union is after the 11th of May 2000 enforcing its right to the benefit conferred by a term in an individual contract of employment. I say that is the pair to the apple.
Yeah, well, you're saying that the agreement in which it appears changes the character of the benefit, and I'm wondering whether that's really the case.
The agreement together with the paradigm shift in the legal landscape.
It's the 99 without the 99 hours.
Of course.
Yes. We wouldn't be here. Yes.
Yeah.
It doesn't so much change the nature of the benefit, it changes the nature of the obligation, doesn't it? Because previously it's an unenforceable obligation, everybody agrees. Yeah. Now it's an enforceable obligation, enforceable by a third party, not just the immediate parties thing, unless the contrary intention appears from the proper construction of the contract.
Yeah.
You've got three.
But it's always been enforceable. It's always been enforceable by the employee.
Well, you could have. There are three stages. I agree with the implication of my lord's last observation, which is stages 1 and 2 normally happen simultaneously. But collective parties agree something. Conceptually, that's stage 1. Stage 2, that is incorporated into an individual contract of employment. And most things that are collectively agreed are, but by no means all of them. And sometimes, as in this case, in fact, parties give some thought to expressing which terms should be collectively incorporated, and incorporated to individual contracts of employment, and which should not. And sometimes the courts have to say, well, this is the sort of term which is, and the most used is apt for incorporation, and at other times not. But they're two conceptual stages. That stage 2 gives right to individual enforcement rights by the employee. Stage 3 is the Third Parties Act comes into force, And that give right, in very narrow category of terms, to the third party being able to enforce. And I still, and I promise that this is not rhetoric. If I can't see the wood for the trees, then mea culpa. But I still cannot see why the fact that when there was no third party act at the collective level, the union couldn't enforce, sheds any light on whether, when there is a third party act, the union should be able to take advantage of it in enforcing a term that was agreed between the individual employee and employer. But I realise to some extent I'm going round.
Well, I'm beginning to think, it's been very helpful, I think, I hope to all of us, but I'm beginning to think that we have really explored this as far as we can. If there are particular points you haven't had a chance to make, please make them, and we will, within the limits of our obligation to understand your arguments, keep quiet and hear them. But I think we probably wanted to move on to the other issues.
My Lord, it's a timely intervention, but there is nothing else I really wanted to say. Just to recap, though, that I would urge you, after all of the intricate and to some extent nuanced analysis, return to the proper construction of the contract. And you would have to find, I think, my Lord says it the way that my learned friend puts it, but you would certainly have to find that there was some process for implying from that factual matrix either, well, it would have to be, it was so obvious. But I do remind the court, I don't need to, I know, that the narrowness of the officious bystander test has been repeatedly stressed, and in Marks, Spencer's and Paribas, it was stated in terms that a term should not be implied merely because one considers that the parties would have agreed it if suggested to them. It's much higher than that, and I agree, my Lord put it more highly than that. But it really has to be that high. So, my Lord, that does leave only the section 10 point. And I can deal with this relatively quickly because I've already taken you. Well, I should remind you of the statutory words. Section 10 provides that the Act doesn't apply in relation to a contract entered into after the relevant date. So that the words are a contract entered into. And those are the words to be construed. You've seen the, insofar as you're prepared to take it as illuminating this point, the purpose of that provision at 14.20 of the Law Commission report. You've heard me talk about employment contracts and their particular features and the onus I suggest that puts on employers because of the long-term nature, because of the inequality of bargaining power, that it wouldn't perhaps put in other circumstances. That means we say that it is appropriate to interpret those key statutory words entering into a contract widely so as not to exclude situations where employees take on new roles with new salaries and new hours at work. And I do say, I know we're in a courtroom, but outside of the courtroom, it is commonplace for someone to talk about getting a new contract at the same place of work. And that's partly because, and this is an important point, and I take somewhat ironic issue with my Lord Justice Lewis's suggestion of you either get a piece of paper or you don't.
I'm just very
No,
simple. I just find simple things help.
I know, my Lord, I was...
Yeah.
It is a matter of happenstance that these employers generally, as far as we know, and did not in these cases, issue new contracts in that sense when, for example, promoting to a new grade, new hours, whatever.
I think you've got to look at, because I'm sorry about this, but Mr. Davey, in my example, I'm just trying to go, what he had was a contract said, which you work for the Home Office, and then he was switched from Waterloo.
I'll come to the facts.
And I don't see anything to see any different terms or things other than the things that resulted from the switch. So there wasn't a new contract entered into. Bits of the sentences, bits of the arrangements in the original contract had to be tailored to reflect the new situation. There wasn't a new employment relationship if you want to get away from contracts, and there wasn't a new contract entered into, perhaps. All there was alterations in details not material to the check-off point, to do with the fact that he wanted to go from Waterloo, goodness knows why, to Croydon?
Well, I won't try and shed any light on that, but this time the devil really is in the detail of the detail.
I think so.
But I want to first start with a point of principle.
Yes,
and then
well, I
descend
think the
to
point of principle is genuinely very difficult, and
But I do want to make a point that I hope will find favour, because it seems to me so obvious, but I've been wrong before. There is, in the civil service, as we know, a large core of common terms across the civil service. And we know it's been more convenient, however substantial the translation. You know, whether it's from grade 1 to grade 7, not that I suspect that ever happens, you always get a piece of paper, the effect of which is broadly, this is what is changing, the rest stays the same. As opposed to, here is a new piece of paper with the word contract on the top, or even fresh statement of terms and conditions on the top. But that is happenstance. It cannot be sensible to interpret section 10 in one way for this employer, but in another way for a different employer who effects the same substantive translation to a new job in a different form, as F.W. Farnsworth did for Mr. Lacey, for example. So that was exactly what happened in Mr. Lacey's case. He was promoted, and he did get a piece of paper that said, here's your new contract. Now, if that were the test, and I don't say it should be, but if that were the test, then you'd have the, I would suggest, unacceptable situation where, depending on whether the employer gives a piece of paper in the same substantive circumstance,
Forget that, it could be an implied piece of paper.
Well,
I was doing it visually.
I think you're maybe a point you want to emphasise, but I think you're pushing at an open door. It must depend on substance and not form.
Yes.
But as soon as I'm glad I'm pushing an open door. But as soon as that door is fully open, then it's fact and degree.
Well, it can't be. It can't be as. I'd be very sorry if it was as diffuse as that. There must be some principled basis for deciding what is a term, what is a change that is recognised as entering into a new contract, and a change that isn't.
Well, I agree. There are absolutely. I'm going to suggest some, but the courts will, in time, have to delineate the black, the white, and the grey. But there will always be grey. I mean, let's take, I hope, an uncontroversial example. A janitor becomes a permanent undersecretary with the same employer. Is there anyone in this room who says that's not a new contract?
The two examples that are the subject matter of the appeal are very much more difficult ones. One is a temporary promotion, and the other is moving from Waterloo down the street to Croydon.
I will come to the fact.
Yes, I'm going to pull rank. I don't think it's helpful yet to get at those examples. I promise we will. But okay, fact and degree. But what sorts of changes? Is it changes in job duties? Is it changes in responsibilities?
So there's two ways of looking at it, which are effectively two sides of the same coin. One is by the language, using the language of cases like the ones you referred us to helpfully, my lord. Is it Potter and Neely, and the case of Mulchrome itself, which is the only case under Section 10, where the distinction is drawn broadly between what is considered to be fundamental and what is considered not. Now, in a sense, that doesn't take matters much further. So you have to ask yourself, well, what is a fundamental change, or what are fundamental changes? And we would say that a promotion in the normal state of affairs, and certainly in layman's sense, does qualify as such a fundamental.
Well, yeah, maybe. Can I just test that? I mean, you can have a very, forget temporary, you can have a permanent but very minor promotion. Instead of becoming the assistant paperclip collator, you become the deputy paper paperclip collator.
I heard it the
Sometimes
other way
differences.
round, but-
Yes, all right. Sometimes differences in title are insignificant.
I agree, my lord. And
You're just in a saying. I do understand. We come across this in all sorts of areas. It's question of fact and agree. Promotion will normally be enough, but perhaps if it's a very trivial promotion, it won't
I
be.
agree. I absolutely
Yes,
agree.
I see.
Can I suggest we have one touchstone that will be very familiar to my lord of Justice Underhill, and it's at page 5 of your authorities bundle, because for many, many years, Parliament has said these are some terms which we think are so important, so fundamental to contractual employment, that the employer has an obligation, when it employs a person, to set them out. And an employer has an obligation, if it changes any of those terms, to set out those changes in writing and give it to the employee. So I know that the word fundamental isn't used here, but that's what we're talking about. And in subsection 4 on page 5, you've got the list. And it's exactly what you'd expect. Pay, hours.
Well, hang on.
You've got 3. You've got the date when the employment began.
No, I'm on subsection 4.
Yes, forget.
I know, but that's a shall also contain.
Yes, I understand, but those aren't...
No. But just looking at 4, yeah. Well, this is a ingenious and in many ways helpful approach, but it begins to fall down when you look at the detail, the scale or the rate of remuneration, or whether it's. Suppose you were moving from. There's the interval to which remuneration is paid. Suppose you were being paid on a 28-day basis and it's changed to a calendar monthly basis. Is that entering into a new
Of course
contract?
not, my lord. I'm not suggesting that every word within subsection 4 or section 1 of itself constitutes a
These
fundamental...
are possible indicia.
They are indicia, and they are indicia when you look at them, as it were, not with a microscope, but from a sensible distance from which you can still see them. And what are they talking about? How much you get paid, how many hours you work, what days do you work, 5-day week, 7-day week, what's your holiday entitlement?
Who you work for. It's going back to 3, but who you work for is fundamental.
Oh.
Yes, I'm taking it as read at the moment that we're talking about people.
Oh yes, same employer. If it's a different employer,
employer.
you must have a new contract.
Although,
Although the civil service,
you're obviously right, my lord, subject to the point you were about to advert to, which is, are they all actually employed by the same person anyway? But we were talking substance, not form. How bizarre would it be if section 10 had the effect of applying the Act to someone who moved from EO3 in the Passport Office to EO3 in the Home Office? Or, as we now know, there have been massive reorganisations,
Yeah, quite.
new departments created, old departments destroyed or merged. So your job's the same, you sit at the same desk, you do the same work for the same money and the same hours, but some politician has dreamt up that you should now be working for a different, in quotes, employer. The Act applies. But within that employer, you move from janitor to not just assistant paperclip provider, but the paperclip provider. That's something very different. The substantive change is obviously much greater. If you, at the same time, double your money, work 5 days a week instead of 7, have 35 days holiday entitlement instead of 24, etc., etc., it becomes even more absurd that they should not constitute entering into a contract if moving across from one department to another, doing exactly the same job and possibly literally not moving at all, does. So we say that yes, indicia only. No one's suggesting, I don't anyway, that...
I think, just pausing, I mean, the point about machinery of government changes is a real point, isn't it? Because ever since delegation, you get nightmarish problems within departments, often equal pay problems, when something moves from the levelling up department to the, I forgot what all the departments are called now, but to BAIS or whatever that's now called, are doing, as you say, exactly the same job, but because they're now part of another department, the details of their remuneration are different, or the grading structure is different.
They may be, they may not be.
No, but very increasingly they are different to some extent, because we've had 20 years of divergence.
Yes, I mean, yes, they certainly
Yeah,
they could
but we're not going to get anywhere with this, but it's simply illustrating that much as I am looking, even a nice simple touchstone like same employer, or change of employer must be a change, it's actually complicated.
I agree. I'm for substance, not form. A change of employer in a substantive sense, definitely.
Yeah.
I should say this, but I won't. Suffice to say, there are difficulties at the moment in knowing who your employer is.
Can I just
people sorry, employer in the sense of the delegated employer. So I would find it hard to defend the proposition that someone who literally turns up to work the next day and doesn't even know yet whether they're working for Department X or Department Y has had a fundamental...
Can I just summarise where I think you are on this, otherwise we'll get lost in a welter of detail, for which I'm partly responsible. You have said fact and agree, and you can, if you like, say whether the touchstone is whether it's fundamental or not, but as you acknowledge that's just a word and you still, that's really just saying fact and agree in another way. You're really saying that there is no escape from a fact-sensitive inquiry, however inconvenient that is, and it is inconvenient, in looking at the application of Section 10, to saying whether a particular set of changes amount to entering into a new contract or not. Is that really what you're saying?
Yes, and it's a burden that was happily, well, I don't know if it was happily shouldered, but it was shouldered by different courts in the cases that we have referred to, including Mulchrome. The courts, that both in the employment context and the non-employment context, have accepted that there will often not be a bright line.
Yeah.
And
so I should stop. I should accept the inevitable and just say fact and agree, and then we can get to my lord's point and look at actually the facts and agree in these cases, which may have some illustrative value.
Well, I've now joined the General Party, and I did that to
poor old Mr. Davey will have to wait his turn.
I'm back at Section 10 again. I know I'm obsessed. Somebody just mentioned there was a new contract. It doesn't say a new contract.
No.
I've had two thoughts.
No, it says
contract. You could say any change. On Monday, I had a contract which said I worked at £5 an hour. On Tuesday, my employer said, gosh, you're a jolly good judge, I'm doubling it, you get 10 quid an hour. That is a contract. It's not a new contract, but it is a contract. So why isn't any set of contractual provisions that come into effect trigger the Act? And then that made me think, well, hang on a moment, when they talk about contract, perhaps that's because they're talking about the contract, they're talking about the things that the Act is meant to apply to. And I wonder whether it's the contractual term, that is the subject matter of the claim for enforcement by the third party that it's getting at.
This is a point
but that's
my Lord
hard
made
to
yesterday.
put at. It's hard to do that with the wording of the Act, I agree, because it talks about a contract rather than it's the contractual
Yes, I mean,
term.
against myself, the way I read it is that entered into is an important part, a critical part of the statutory formulation. And I think that the example you just gave, my Lord, would not, in normal layman or legal usage, be entering into a contract.
It would be varying a contract.
Exactly.
So if it's something that's a variation, but that's important because then you've got a contract, which might be a synonym for contractual relationship or an employment relationship, and then variations, alterations to that aren't entering into anything. So it's got to be something that, as you said, amounts to a substantial change.
Exactly.
The curtain comes down on that, and you say, I'm no longer a janitor. I'm now permanent secretary of state of the Home Office. They've run out of everyone else. I'm the only one left in the building. And
I mean, I think, if I can be so bold, and you may all three think this is a wishful thought, but I'm not sure the elephant is going to be that hard to recognise when you see it. Defining it in advance, as we know, is not so easy. But I think if you ask the average layman or lawyer, has this person entered a contract, there will probably be a reasonable consensus. And there will certainly be things that obviously fall on the wrong side of the line, like my Lord, or Justice Lewis's most recent example. And it would seem to me there are things that must fall on the right side of the line, whether or not you get a new piece of paper. See my earlier examples of janitor to permanent undersecretary. But yes, there will be some animals that judges may not agree are elephants. But I don't think it's going to be quite as tortuous.
Well, we'll have to see. But in fact, now what we've been doing for the last 20 minutes is just exploring my concern, which I think to some extent is shared by my lords, at having no real test other than fact and degree and fundamentalness. And you say, well, there is no escape. And actually, it's not so bad. It won't be so bad in practice. And you'd have the same problem in other statutory contexts, as we have seen from the Potter case. It's really all there is to be said, isn't there? Before we get to the individual.
I mean, what I was seeking to do was to knock down what I consider to be something of an Aunt Sally of recent creation, that you can draw a bright line between, for instance, staying within one department and not staying within one department, or even, against me, moving from one department to another department or to a renamed department. There are no bright lines, but there are categories which seem to me to obviously fall the right side for us. And one of those categories, until this morning, was agreed, namely a substantive promotion. And it seems to me that should still be agreed, as soon as one accepts that it is fact and degree to any extent at all. And the previous reliance, sparked by a question from the bench, was based on this notion that because the civil service doesn't give new contracts, when, however substantial the translation.
Yeah, well, don't worry about this paper.
That.
I think we're all.
I wasn't trying to get to that. I'm trying to make it simple to
absolutely.
understand.
So can I turn into...
But you say substantive, can I just, on that point, you still say substantive promotion should be one. Do you say any change of grade within any civil service department?
To be honest, my immediate reaction is I don't know enough about civil service.
No, well, that's a perfectly honourable answer.
I would have thought intuitively yes, but if someone were to say to me, but hold on a minute, EO3 and EO4 are basically two shades of exactly the same thing, except one gets to wear a hat and the other
Well, there
doesn't.
are big Rubicons. If you get above a certain level, if you get what it used to be grade 5 or something, you can actually do witness statements for court and things. You know, they're big, and then you go into a separate pension.
So I don't
It will depend on the grading structure also, because you will often have subdivided grades, A to E, and you might say which have 1 to 5 within them. Moving up 5, 4, 3, 2, 1 within any particular grade wouldn't be a substantive promotion, but moving to a new grade would be, perhaps.
Yes,
But look, I think
I'm probably the person who knows literally least in the room about such matters.
well, I doubt that. But can I just, before we give up on this point, just try out one point which my lord raised yesterday and briefly again today, and does have a certain appeal, but she acknowledged is difficult to reconcile with the words. If you look at the purpose behind this, the purpose essentially is that someone who didn't think they owed a duty to a third party is suddenly saddled by a change in the law with owing a duty to that third party. So shouldn't one really be looking at, although it uses the language of enters into a contract, the question of whether or not the contract into which they have putatively entered includes the term of which the third party has the benefit.
Or, more simply, I would suggest that from the passage of the Act going forward, every employer, particularly the government, but every employer had the option on any substantive change for one of their employees to say, here is a new contract, or as this employer does, here is a list of the things that are changing, one of which is the rights of third party act will not apply. Simple. Mr. Davey, Mrs. Speakman, they could have been written to as they were each time we say a fundamental change happened, though it's still up for grabs whether it was sufficiently fundamental, I understand that. But if it was, the employer could have written and simply said, the following is changing. Your money's changing, your hours are changing, and the Contract Rights of Third Parties Act does not apply. That's all they needed to do. And it was their obligation to do so, we say. And if they didn't meet that obligation, tough.
But would it work, though, what my lord put here, that does not apply in relation to a contract containing the term that the third party is seeking to enforce before the end of the period? So if the changes are not of the contractual terms that are the sort of third party enforcement, then that's not a contract entered into for the purpose of Section 10. The wording is difficult, but can one...
I don't think so. I mean,
It's just because the wording is just, you can't change the wording ultimately.
no, and also, and this has been the genesis of this whole litigation. You can't get rid of a contractual term unilaterally.
No, this is
So
a different
I
point.
understand,
Yes,
but I'm just saying. So the background is that when Mr. Davey gets promoted, they couldn't have just written to him and said, "Oh, by the way, the term doesn't exist." They couldn't have wished away the benefit conferred on PCS by that term without his
But they
consent.
could say promotion is conditional on you agreeing to dispense.
True, they could do that. They could, in other words, secure his agreement, or they could just say, "Will you agree that from now on, the rights of the contract rights of third party act does not apply?" I mean, we can come back to issues of principle, but it may help to start looking at the two cases because.
Let's.
So, I freely accept that in our written argument we have relied in each case on perhaps more changes than are warranted on reflection. So I'm just going to stick to the ones that we say are the high point. We only need one post 11 May 2000. So Mr. Davies' case, he was the one who was appointed in 1987 as the immigration officer. You may want to look within the Cox supplementary bundle at the relevant documents while we're skipping through this. So the supplementary Cox bundle, I think it starts at page 39. So he's an immigration.
Well, I think they've left out the word officer, actually.
They have, yeah, in the Home Office from 1987. Now, various things happened to him, but the important thing, if you go to page 60, important for our purposes, meaning the chronology, it's after the 11th of May 2000.
1-6, did you say?
No, 6-0.
Thank you.
I stopped at 43 en route because it's... No, that's... No, 160 then, yeah.
So he there is translated.
So sorry, I'm behind everyone else. Which page am I meant to be on?
6-0, my lord, of the Cox supplementary. There should be a letter dated 17th December 2003. No? Have I got the page wrong?
No, sorry. Sometimes the page numbers are impossible to find. I was looking at a different set of page numbers.
Yeah.
60. Yeah, I've got it. 17th December 2003.
Yeah. Sorry, my learner friend hasn't yet.
It's not in the electronic.
Okay.
Well, anyway, it's the one that has 60 written on the right hand, which...
Yeah, I've got it.
Yeah. So he's now going to transfer from the immigration service at Waterloo.
My lord, I think the version we've got is not that page, and so I'm not following it.
Well,
Which document is it?
it's very annoying when people can't get bundles right, but or it looks like Mr. Siegel and all three of us have at supplementary bundle 60 a letter from the Home Office to Mr. Davey of the 17th of December 2003. If you haven't, I'm sorry about
My lord,
that.
I've got a
blame
hard
someone
copy,
else.
And now
I
now have a hard copy.
Okay, I don't know whether Sedley's law of bundles predated the internet, but another Sedley law is it shall be a rule that whenever there is an electronic bundle, the numbering will not correspond to that of the hard copy bundle. And it's a shame that by now people putting these bundles together haven't learnt this, but there you are. Not Mr.
Every
Feeney this time,
judicial
I'm sure.
direction should contain the direction. that electronic numbers must correspond to.
Well, look at the luck we've had with practice directions.
Okay,
Page
let's step back.
60,
Let's step back to the
60,
substance.
It starts before. It starts in 57. He was transferred for an initial period, although that occurred in September 2001. That's when he went to Croydon, first of all, initially for 6 months. And then he was still there in March 2003. And he's been successful, it seems, for a permanent transfer. And he wanted a permanent transfer. And then the 17th of December letter seems to be confirming that, although they all seem to have started, as far as one can tell, after the 11th of May.
My lord is right. There were temporary arrangements entered into earlier. I'm focusing only on, as it were, the high watermark of Mr. Davies' changes, namely the permanent translation, which is confirmed by this letter.
And all that at the moment means he's moving from Waterloo to the third country unit, and that will now be for 2 years, not the 6 months previously extended. And there's something called permanent compulsory transfer firms that apply,
And then, if you go to page 62 and 63, you see the changes to what I say are the fundamental terms within section 1.
Yes, but you don't know, because we don't know what his salary was before. We know that his salary would be 23,100, but we don't know what it was before. So we don't know if it's a change. We know the London allowance changes because he goes from Waterloo to Croydon, and they've got this peculiar thing whereby you keep your inner London allowance until your salary catches up, and then things are evened out. But you just can't tell from that what it was before. So if you're saying there's a change, you have to show us what it's changing from. Do you follow me?
I do follow you, my lord, although I think it's a reasonable inference.
Well, I didn't even find Mr. Justice Choudhury, I didn't find the facts.
Reasonable inference.
That what they are setting out in that and the next page are the changes to, not the continuation of existing.
Well, I dare say that's so, but I think my lord was wondering how big the changes were.
Well,
if your salary went up by £5 a year or down by £5 a year, that probably would suggest we weren't looking at a fundamental change.
And I couldn't find what facts Mr. Justice Choudhury found.
This was all part 8, wasn't it? So there weren't any witnesses.
There were witness statements.
Yes,
that doesn't help either. If you probably have read them. I read them.
I did
at
read
home,
them
not
once.
on a train, and I didn't see anything in them that helped on the details.
Sorry? Sorry, I'm just trying to find the relevant part of
I mean, his statement's at 159. But it doesn't go into the details.
Yes, well, perhaps unhelpfully, effectively my submission is recorded that these were changes, and on that premise, the judge has made a conclusion. We don't know the extent, I accept.
Then how can you prove that it was entered into after the 11th of May 2001? It's for you to prove that, isn't it? If you want to get the benefit.
Well, as
It's
I say,
all a very confusing letter
I think
anyway.
on the balance of probabilities, we have proved a change in salary. What I do accept, though, is we don't know whether it was a change of £500 or £5,000.
I'm not even sure you say that's shown that, I must say.
No, I don't think you have to, because I just, with the greatest respect, you've assumed that because the letter came saying this is your salary now, that there must have been a change. You've assumed that, but we just don't know enough.
Well,
and
look,
it is for you to prove. And Mr.
my lord is
Choudhury
right.
doesn't find facts that help you.
My lord is right, but I'm not suggesting that any of you is unaware of this. It doesn't matter whether Mr. No, but can I? It doesn't matter whether Mr. Davey, as an individual, had a fundamental change to his contract. What matters is that the court tells the parties what a fundamental change is. So if the court were to say, for instance, if, as Mr. Siegel suggests is likely, Mr. Davies' salary changed substantially at that time, then, along with these other changes that we can identify more precisely, that would constitute him entering into a contract. However, Mr. Davey and Mr. Siegel have not actually demonstrated that, so in his particular case, we find it is not so proved. Makes no difference at all. Not even one iota of difference.
Well, first, it means we allow the appeal in his case. And
You're-
secondly, he doesn't get a declaration, and you may find he's quite upset by that. But call me old-fashioned.
No, I don't at all. I'm not making any concession. I'm simply saying that
Other people will win, but he won't.
well, can again we be clear? When you say he, my lord, we're talking about PCS's claim now, not Mr. Davies' claim.
No, the appeal
Mr.
is
Davies
against-
got his declaration
But I thought they'd appealed it.
only on the ground of variation and waiver. The declaration that PCS want
Yeah.
is in respect.
This point is only relevant to PCS.
This is a section 10 point, and by reason of the fact that Mr. Davies is one of those who actually switched to direct debit, PCS has no claim in respect of loss in respect to Mr. Davey anyway. He's only here in an attempt to provide the first instance court with a spread of types of change so that the first instance court, and now you, can articulate sufficient principles for the parties to then go back, as they did in Kavanagh, without the benefit of the Court of Appeal judgment, to say, right, obviously in that case it was by compromise, but these are in, these are out. These people we have to accept did not enter a contract after 11th of May 2000.
I mean, we've got the point.
So, but what you have said is obviously right, and I don't shy away from it.
Right. Anyway, we have here anyway an illustration of a particular fact situation where people move location. The character of the job is obviously a bit different. Sorry.
We know these things we do know. I say we know there was a change to his salary, at least on the balance of probabilities. I accept we don't know whether it was extensive, that change. We know his duties changed, we know his days changed, we know his hours of work.
So his duties change, his what change? What was the second one?
His days.
Days change, yeah.
And his holiday entitlements, which is basically pretty much
And just
the full
show
house.
me the pages that the bit that says you're no longer entitled to holiday pays, you no longer work weekends. That may not be a change, you see. I mean, not a change in the contractual terms. The contract may always have been if you work weekends you get this, but now because you've chosen to go to Croydon and it's 5 days a week, not 7 days a week at the Eurostar, you're far short of having the kind of facts that would actually help us understand how these things are working. We just don't have anywhere near enough from his written statement or the letters that you've shown, for Mr. Davey particularly. Well,
I would say that's a little harsh in respect to page 63. I'm writing to inform you that with effect from that date, you're on a permanent compulsory transfer from one place to another.
yes,
Your
because he's been on 6 months and now it's 2 years and there's permanent compulsory test. We don't know whether that's really significant or not, but anyway, it's there, yeah.
Yeah. From the date of the transfer, you will cease to receive holiday pay as you will no longer work weekends.
Yes. Your contract may not have changed. Your contract may have said if you work weekends you get this, if you don't work weekends you don't. So there's no change in the contract. He's chosen to move, and as a consequence of choosing to move, he doesn't get it. We just don't know, Mr. Siegel.
I think we've got.
Well,
I think we may have run this one dry.
Yeah.
Haven't we?
Yeah, I mean, I don't dissent from the proposition that it would be a lot better if we had two contracts, one before, one after, and we could compare and contrast, and we don't.
Yeah,
and
okay.
I had assumed, and I think to be fair, everybody had assumed, the other side and the judge, that what was set out at pages 62 and 63 were changes, though I accept no finding was made as to the extent of them. And as I say, what is more important, if you know, nostra culpa, if we've put the wrong facts cases forward, we apologise. But what is more important is
what you want from us. This may at least have provoked some thought, even if we can't make findings about this particular case. What you want from us is the best possible guidance as to what will count as a change and what won't.
That's what both parties, in those precise words, I think, asked of the court.
Okay.
And I know, rightly, courts shy away from giving general guidance.
Especially in the absence of concrete
Yeah,
facts.
I
really do think that. And they've done witness statements and they've told us nothing.
I agree.
Okay. Right. Well, I think let's.
Anyway,
are we
stay
to get
here.
anything more out of we'd have any better luck with Mr.
No, it's Mrs. now.
Mrs. Sorry,
Yeah.
of course.
Mrs. who starts out life, I think, as Mrs. McMasters, but quickly
Yeah.
becomes Mrs. Spearman.
Yeah.
So she was appointed originally as a clerical officer. You see that at page 70. Back in the 70s, I think, 1979. And my Lord of Justice Luce is right, we know a little bit more about the status ante quo on the 11th of May in her case, because at 82, so this is just before the Act comes into pass, so we know what she was doing on the date the Act came into pass, came to force, I'm sorry. She is going to be substantive grade, passport officer 3, salary pro rata to 14,425, etc. And then there are a series of promotions and reversions that take place between 2005 and 2010. And I've set them all out we have set them all out in our written argument. The one I want to focus on is at 94, but the other pages are set out mapping the toing and froing between pages 85 and 93. But at 94, this is a real change of grade. This is a sort of AO to EO, I think is the right nomenclature. So I'm writing, this is 2nd of March 2010. So after the Act comes into force, but substantially before check-off is removed. So I'm writing firm, you'll receive temporary cover allowance to cover duties as a temporary EO with effect from that date. And the allowance will be granted to cover duties for 60% of the year. So she's moving from what was her previous full-time role.
Sorry, incidentally, you say it's a change from AO to EO. That's what the evidence is it? I mean, she was.
Sorry, it's my mistake.
It was an EO before.
PO, I forgot. From PO3 to EO. So the last grade issue was 89.
Yeah. Okay.
Sorry, I shouldn't have said AO. I told you I didn't know much about civil service.
But is a PO roughly like an AO? Nobody knows. Nobody knows. Okay.
I'm told I assume so, but I don't know. But I think what is clear is that EO is a more senior grade than
EO is
PO.
yeah. Okay. Well, she's certainly being moved up on a temporary basis. That's obvious.
Yes.
Okay.
Yes.
Keep going.
That promotion, leave aside for the moment temporary permanent, with increased pay, is what happens until she retires in 2015. So obviously, as an individual, in respect to the PCS claim, A, she doesn't count because she transferred, and B, she retired pretty soon after check-off was removed anyway. But was it the same day? I've forgotten. The idea of including her as a, using the vernacular test, claimant, was we wanted someone who, as well as being on a permanent promotion, was on a long-term, indefinite, temporary promotion, because that was a contested case below. So what we say, and what we would ask you to find, is that if you're with us, of course, on permanent substantial promotion, if you're not, she obviously doesn't pass muster. If she does, if you are with us, then consistently with the analysis of the judge below, if a temporary promotion is for an unlimited length of time, such that it becomes in effect permanent, there's no proper basis to distinguish between it and a more formally substantive promotion, because both involve the same fundamental changes to responsibilities and pay. It's a short point. Remember, we were trying, as we understood the extent of common ground and dispute at the time, to identify people who fell into the grey area. So there were always people we agreed wouldn't count, there were always people we thought we agreed would count. So we tried to pick people who might, well, these two were indeed disputed below, whereas the other two were not.
I mean, there is a feeling about this case that, I'm not criticising anyone in particular, but we've had a number of piecemeal cases from different departments. There's been no general case management. This particular one is alive to the Section 10 point. It must arise in many cases, I would have thought. And two particular people have been chosen, this one to test a rather particular point, which I dare say happens often in the civil service, I don't know. But has there been any attempt to get together with the respondents to say, can we not pick a series of cases in which, if we win on the big points, we'll test all the likely fact situations which may give rise to a Section 10 issue? It's a little bit threadbare, this.
I agree, and I take responsibility for it.
Well,
I think that, I mean, it is right that our side takes responsibility for it, because, as you say, the overture should have been made that way round. But I think and now I do speak collectively, where we fell down, and I accept we did, particularly we, was in assuming that if we gave a few sort of rungs on the ladder, as it were, the court would give us the completed ladder fresh from home base, and then we could take it back and know exactly where we stood.
Well, I mean, the willingness, I'm sure, is here, but speaking for myself, I just don't feel and I've done plenty of government employment cases over the years, both at the bar and on the bench, but it's taught me that pay structures are much more complicated than they seem, and they vary between departments. And I would be very unwilling. Take, for example, when I was growing up, everyone thought in the civil service the big divide between AOs and EOs. I gradually realised it was a lot more complicated than that. In theory, we could say a change from AO to EO would be a new contract, but various different subgrades of AO wouldn't be. I don't think we got the kind of material to lay down the law in that sort of way.
Well, my lord, I'm not pushing back on this.
No.
I think what I would suggest is that where you're all content to draw relatively bright lines. I mean, you might draw a bright line as the appellants are arguing, in which case none of these people get a look in.
Right.
But if you are able to draw some bright lines, draw them. If I would assume you can at least draw some, and it may be that we have to then go back for determination prior to or as part of a remedy hearing in respect of other specific facts cases where there is.
If there are 7 cases in the pipeline, I don't know whether that means 7 cases, or maybe they may all have multiple claimants.
They are multiple claimants.
I don't know whether
employers.
Is it Thompson's acting for all of them?
I believe so, yes.
Same sort.
Yeah.
So maybe some thought has been given in choosing those ones about Section 10 issues, or maybe it hasn't. I don't know.
I'm sure it has, but I wouldn't be as sure that enough.
Yeah.
I mean, I know that because I was to a minor extent party to it, I know that the intention was to provide a spread of factual.
Yeah, you actually need the facts. I hate to be old-fashioned.
Yeah,
no, my lord is right. It's not that we started off on the wrong foot. It's that we put the wrong shoes on.
Well, no. Well, I think we've got as far as we can on that as well. I mean, just out of Kavanagh, there were only 2, weren't there? Yes. So,
yes, I mean, as I say, in Kavanagh, the
same
same issues.
Section 10 issue didn't arise in Kavanagh, or did it?
Oh, absolutely rose. Yes.
Did it? I forgot.
Wasn't it sent back because the evidence wasn't there then?
No, because remember in Kavanagh what happened was that the court decided the high-level issues of remedy, and then the parties had this battle discussion and resolved it.
Right.
But it's obviously not binding on future
Okay.
parties.
Well, I think, thank you, again, it's been slightly undisciplined, but it's been helpful all the same. That's really all you have to say on Section 10.
It is.
And that's therefore your submissions.
They are.
Thank you. Yes, Mr. Sheldon. Oh, sorry, either my lords.
My Lord, if I can make a few brief points in reply.
Yes.
I'd like to just touch on the question of variation and what was in fact decided in Appellant and how that should therefore play out in this case. And then I'd like to deal with some issues around the collective agreement points in terms of section, as to whether section 1 applies. Well, with respect to variation, obviously everything turns on the particular circumstances of the case, and one relevant circumstance is whether or not protest took place after implementation of the contractual change. My submission on the basis of Appellant and what you were taken to earlier is in fact the ratio of Appellant is that there needs to be protest after the change has been given effect to. That is what the cases that preceded Appellant decided, whether, or certainly that was the dicta within them, and that is the decision within Appellant itself. And that makes complete sense in the employment context in any event. And if I can just go back to Appellant, ask you to turn that up. My lords, you have Appellant at page 173. Firstly, the issue of protest after the breach is, my submission, the fact pattern of Rigby and Perodo. That is, which is, and we've got Lord Oliver's speech at paragraph 73. Where he says, his lordship says that at the end of that paragraph, I can, for my part, see no other basis upon which it can be argued that the continued working by Mr. Rigby and his acceptance for the time being and under protest of the wage, etc. And that is then analysed, and I say correctly, by Lord Justice Underhill in paragraph 74, because it must refer to the protest by the trade union, because there's no evidence of any individual protest, and that protest continued not just before the change came into force, but thereafter. That's the reference to ACAS. Up to the date of the issue of proceedings is what is said there. So if we're to take anything from Rigby, it's the way in which Lord Justice Underhill interprets it, in that there was not just something took place in advance of the change, but there was continued protest thereafter. That is also, my submission, the proper way to read the Jones, the dicta in Jones, which is quoted at the next paragraph, paragraph 75, in the words of Mr. Justice Brown Wilkinson, in the middle of the quote, whereas in the present case, if the variation relates to a matter which has immediate practical implication and the employee continues to work without objection after effect has been given to the variation, then obviously he may well be taken to have impliedly agreed. So again, the focus is on protest after the date of the application or implementation of the contractual change. So that's the evidence there. And then when one looks at the judgments themselves of both Lord Justice Underhill and Sir Patrick Elias, they also focus in their ratio, or in the ratio of the case, on protests taking place afterwards. If we
Are they making it a legal requirement, or is it just the facts of that case there was protest afterwards, and therefore the ratio of that case is where there is protest afterwards, and this case would be the one that decides as part of the ratio whether or not protest before?
Well, it may be that this court is going to have to decide something different.
But are we bound to say that there has to be?
My submission is that you are bound on the basis of the precedent of Rigby and Perodo and of the judgments in Appellant to find that. If not, then and I'll also make a submission as to why you should. Because the third proposition that Lord Justice Underhill relied upon, which is at paragraph 104, and you may recall how my learned friend described it this morning, sets out the principles, then applies them to the facts of the case. This is the ratio, 1, 2 and 3. The first sentence of Lord Justice Underhill's judgment here is, there was strenuous protest on the part of the unions, not only up to, but beyond the date of the implementation of the freeze. And then there's a whole discussion about what took place thereafter. Similarly, at paragraph 111, which my learned friend says is the nub of Mr. Patrick Elias's judgment, Mr. Laddie put forward some powerful reasons why the employment judge ought to have found there was acceptance of pay variation here. In particular, the lengthy period of almost 2 years without complaint and no pay increments were given. However, I agree with Lord Justice Underhill that the judge was entitled to take the view he did. And then there was initially objection to the change, and thereafter, once the decision not to take industrial action had been taken, etc., and that decision took place after the pay freeze had been introduced. And
So there was no further protest.
Look, there was further protest after the pay freeze, because
That's
the
not what-
decision not to take industrial action was after the pay freeze had been introduced. Up until that point in time, the union was continuing to protest the change. We picked that up at paragraph 68, which is the setting out the findings from the employment tribunal. Paragraph 70 within that, so the paragraph within paragraph 68, 70.4, ACOS decided at a meeting on the 8th of March to go ahead and implement the pay freeze with effect from the 1st of April 2011. So that's when the breach of contract occurred. The unions in or around early April 2011, therefore after the 1st of April.
They did that, but there was no further protest.
No, but consulted their members about taking
I thought you
industrial
were
action.
saying it was ratio that there had to be further protest after the implementation of change.
Well, because what Sir Patrick Elias is relying on, he's referring to this period in time, which is after the implementation of the pay freeze.
Well, I'm obviously being very stupid, but 70.5, the fact that they balloted was insufficient, and so they just left it. And that's what Sir Patrick says at 111, so there's no further protest.
No, but he's saying that that period is an expression of protest.
No, surely he's only saying they don't do anything to change their position. That's what he says at 111.
There was initially objection to the change, and thereafter, once the decision not to take industrial action had been taken, so he's
Neither the unions, the employees, nor the employer clarified their position, so it was just status quo.
Well, my reading of what Sir Patrick Elias is saying there is, up until that point, the union had continued to protest. Even if I'm wrong on that, my lord, he has accepted, I agree with Lord Justice Underhill that the judge was entitled to take the view he did, and Lord Justice Underhill makes the decision on the basis of the point that's set out in paragraph 104, which is that there was strenuous protest.
Which is one of three described as particularly important.
Yes, but that is part of the ratio of the case, which is consistent, my lord, with Rigby and Ferodo and Jones. Certainly Jones, because Jones says it in exact terms, and also Rigby and Ferodo as interpreted and explained by Lord Justice Underhill at paragraph 74, which is the only possible interpretation, given that there was no individual protest by the employee concerned. There is, my lord, a reason for why that should matter, which is that there is to use my Lordship, Lord Justice Lewis's language, there is now a changed state of affairs when the contract has been changed, unilaterally changed. And it is right that the employees have at that point to say, well, now there's a changed state of affairs. Do we accept this new changed state of affairs or not? It's one thing for them to say in advance of it, this is our position, or this is not our position. But actually what matters is what do they say after that has actually happened, when the pay has been cut, or in this case, when there's been a removal of the check-off. Do you accept the change now that it has impacted on you?
They were never asked that.
They weren't asked the question, but through their actions, and then over a period of almost 6 years, you can infer from that they did accept the change.
Sorry.
But the point of principle is that there does need to be protest after the date of change, and I'm just giving you a reason. I'm giving you a reason why.
Yeah.
Can I just double check that I know I'm obsessive about facts. I've not been here long enough not to worry about them. Page 135 of the supplementary bundle, on the 5th of December 2014.
In which case?
Oh, in Cox,
Yes.
the Home Office, on the 5th of December 2014, the union wrote that we believe that the decision to remove this facility is a breach of the contract and their rights in that respect are reserved. Was the removal of check-off before or after the 5th of December?
The last date of check-off was the very end of November.
So this
So
was after
the first date upon which where check-off was actually removed was at the end of December.
No, when it removed and they did make the... I mean,
They didn't make the deduction. So the first
December, but is there a letter saying it's removed with effect from the 1st of December or...
First of December, I think it was the 30th of November or 29th of November was the last date that check-off was used.
Yes, but mine is a very different question. On what date did they say it would be withdrawn with effect from, even if it wasn't actually going to be
I'll
used?
have to go back and find that date. But
But it's in a sense, I take my lord's point, and one should have both dates. But when you say, suppose you say, we remove it with effect from 1st of December, nothing will actually happen until there is a payday.
yes.
And these employees are paid monthly, and presumably all on a particular date.
But I am going to.
I've
my lord,
got
you
it,
don't
no,
need to. But you don't need to know the answer to this because I'm going to. On
I've
the
got it,
16th,
which is 129, I think.
But on-
It's from Mr. Sedgwick, who says, thank you for your letter concerning the removal of check facilities with effect from the 1st of December.
But my lord, in any event, I'm going to make a point which assists my learned friend on it. On the 16th of January, there is a further letter from the trade union in respect of the grievance. So, with respect to Cox, I have to accept that to the extent that there was protest, there was some protest after the date upon which of removal, whether you take it as the 1st of December or the end of the month.
What's the date? What's the reference to that letter? What's the date?
144. I think it's the 16th of January. Sorry, 13th of January, 2015. But that's not the case in respect of Crane and Smith, where there is no protest after the date of implementation.
And it must be after the date, not the date of the change in the contract, but the date on which the first check-off would fall.
The first check-off would fall.
Or first check-off would otherwise fall.
That's when you. This is where, if you're looking at a pay cut situation, a pay situation, this is when you don't get the extra pay. You get less pay, and here, the individual civil servant would have more pay. And they'd say, "Oh, that's when."
Do we actually have the what the payday in December was? Is it presumably the same throughout the Home Office?
I think. I have the same date written down as my lordship, which is the last check-off date was the last removal was the 1st of December.
Oh, I see. Well, then that.
So I can't assist, but
Well, maybe for all I know, payday may have been on the 1st.
I will see. It should be the end of the month. It would have been the 30th of November. Then it was with effect from the 1st of December.
Yes, I see.
So my first point in reply is that there has to be protest after.
Yep, got that point.
However, that is not enough because one also has to consider the surrounding circumstances, which include the duty of trust and confidence and the employment arrangements that we have referred to before. My Lord Justice Underhill talked about how both himself and Sir Patrick Elias intuitively felt uncomfortable with the idea that employees could continue working even though there is an ongoing breach and they say and do nothing about it. My submission is that intuitive feeling actually reflects good employment law and the fact that in an ongoing relationship and complex relationship such as this, the employees, whether acting on their own or through their trade union, can't simply sit on their hands for almost 6 years before going to court and ask for something to be brought back, which they haven't enjoyed for 6 years, where there is no damages claim. It's one thing if there's a damages claim, it's another thing where they're simply saying, we'd like to restore the state of affairs that occurred 6 years ago. So, to that extent, the passage of time is relevant. My learned friend made the submission that the appellants were not accepting the relevance of the passage of time. No, it is relevant.
So within paragraph 104, if you're going to make the point about
My Lord, I'm
contractual
asked to refer to, or invite you to look at the full text of 104 in Underhill, where there was an argument from Mr. Laddie that his case, the variation took effect from the first payday after the 1st of April. I did not understand and rule out the possibility that it took effect at some later date, but he did not propose any alternative date. We do not know precisely when during the month the payday fell, but even assuming in the council's favour it was at the end of the month, after the results of the ballot were known, I find it hard to see how they're continuing to work as from the date to be taken as an unequivocal acceptance.
Yep, next point.
And then my final point, my lord, is on the collective agreement point, of which there was a long discussion with my lord this afternoon. Just some very quick points. There wasn't an absence of a mechanism. This is Lord Justice Lewis's point. There wasn't an absence of a mechanism for enforceability pre the introduction of the 1999 Act. There was a mechanism, but the parties to the collective agreement chose not to use that mechanism. The PCS or its predecessor could easily have sought to include within a collective agreement the right, enforceable right to sue on at least one term of the collective agreement. They don't have to sue on the entire term, but there was a mechanism available to them. They did not avail themselves of it, and that's part of.
Sorry, what's the mechanism?
The mechanism is to sue under the collective agreement, to turn that into an enforceable mechanism for check-off. The trade union.
That would require your agreement, which you wouldn't have given, wouldn't it?
Well, my lord, we don't know what happened, but there was
Yes,
there was the availability of an enforceable mechanism. It's not as if there was no mechanism. The way
Availability. I don't understand.
This doesn't take us anywhere
Well,
because the fact is there wasn't enforceability. That's your best point. It's your only point.
that there was they had not enforced. It wasn't enforceable, but the point that was being made, and I'm simply responding to a question of Lord Justice Lewis, which was there was the absence of a mechanism. All I'm simply saying is there could have been a mechanism, and they chose not to avail of it.
Sorry, let me just write this down. Could it be a mechanism for what?
To enforce the collective agreement or the term of the collective agreement at the collective level.
Well, separate agreement that clause X, which talks about check-off, shall be directly enforceable.
Yes.
Yeah.
Directly enforceable.
Well, of course, that.
Well,
I've got that point. That is available in law. It was only available in practice. It is open to the parties in law to agree that. Is that your point?
That's my point.
But only if both parties agree.
Only if both parties agree.
Well, all right. Yes. Okay. Thank you.
My Lord Justice Stuart-Smith referred to there being the absence of any action by either side once the 1999 Act came into force. Mm-hmm. My submission is that the mere fact that the government did not, at that point in time, seek to put into individual contracts of employment something which says the 1999 Act doesn't apply, does not go either way, because the government at that point in time one, did not consider this to be a contractual term, and two, would also be taken to have assumed that there was no intention for it to be enforceable by the PCS.
Well, the government had the misfortune not to understand the terms on which it had contracted, but the responsibility for displacing the presumption, as things stand, rests on you, and you didn't do anything about it.
No, but if the government reasonably formed the view that the section 1(2) negatived the intention for the same reason that I've been arguing here, because this derived from a collective agreement which hadn't been enforceable at the hands of the PCS, then there's no reason why they would.
Oh, this
have
becomes circular.
Well, no, but my lord, there can't be an assumption that because they haven't done something, it must mean that the intention isn't.
To my way of thinking, it just means that you can't demonstrate a lack of an intention that it shouldn't be enforceable.
Well, that's
my provisional view.
That may be one piece of evidence, my lord, but the more important piece, and I'm seeking to respond to that by saying all that presupposes, my lord, is that the government had no other reason why that wasn't an enforceable term. They'd only put something in there if they thought it was an enforceable term.
But if they're wrong, that's their own fault. They're stuck with it. They should get it right.
In any way, in fact, as it happens, it's clear they did know that some of the, because we see reference to the correspondence, they did know that some government departments did have enforceable.
Oh, no. I'm talking about here enforceable by the PCS, not enforceable by the individual employees.
All right, but your first point was, as I understand it, that they didn't think these were legally enforceable at all.
Yes, they didn't think these were legally enforceable.
Well, they did think some of them were, because we've seen them referring to it.
Because they had been highlighted as contractual terms.
Exactly.
But I'm not. The point I'm seeking to make here is.
But even in those cases, there's no evidence that they put in that they said that they took any steps to.
Well, that evidence. That evidence is that evidence has not been addressed. That's not a point that's been addressed in the evidence.
Right, but
I don't know. What happened.
Anyway, we see your point on this. Yep.
Then, my lord, there's a question about whether or not there needs to be an implication of a term. My lord, that, my submission, is not the appropriate approach that needs to be taken, because we're not implying terms. The court is being asked to construe a contract to see what the intentions were of the parties to that contract. That doesn't involve the implication of a term.
Well, sometimes it does. The construction of a contract involves
it can do, but it doesn't require it here. It doesn't require it here, but if it is required here, then I rely on it's so obvious.
So which clause of the contract do you interpret as evidencing a contrary intention?
My lord, it's the construction of the contract against the background of all, as I explained at the outset of my submissions yesterday. This is not a term which appears in a written document.
So we're agreed that there's nothing in the contract as such. So on what basis, I'm sorry to be so picky about this, but on what basis do you say that it's proper to interpret the contract, which is silent on the matter, as evidencing a contrary intention?
Well, my lord, those were my submissions yesterday, and I'll go back to those. I'm sorry if they weren't effective.
I'm still trying to understand them.
My lord, we talked about how this term derives from a common root from historical documents. I took you to the reference in Crane. I took you to the other references. Okay. When one construes a contract of this kind, one has to go back to the various documents from whence it came, the various source documents. And the original source of this particular term is the collective agreement. That is accepted, that's common ground. And therefore construing a contract must include looking at the surrounding circumstances from which the particular term derives. That's the same point that was being made by the Law Commission in their discussion of the subcontracts and so forth. Looking at one particular contract, you would say, this says X or this says Y. It's only if you understand that contract is seen within a chain of contracts that you have to construe it in a particular way. Construing the specific contract, you wouldn't do that. You need to look at the surrounding contractual matrix. And that's exactly what we're saying here. The contractual matrix here is go back to the root documents and where does this term originate from. Then, my Lord Justice Lewis asked a question about, in a sense, reading section 11B with section 2 together. And my submission is that the individual contract can still provide a benefit to a third party, even if that third party can't enforce it, even if the intention of the individual parties to the contract is that party C can't enforce that particular term. So the mere fact that there is a benefit is not the end of the story. The question is it enforceable by the third party? Not is it enforceable at all, because it will always be enforceable by the parties to the contract, by A and B. The question that the 1999 Act poses is it also enforceable by C? And then the final matter I just wish to put forward is if the court is minded to think about what was the state of affairs in 2000 based on the daughter of a civil servant has started coming in. I think what one needs to be extremely careful in doing so.
I won't go
without
any more.
Understanding broadly the the industrial relations circumstances. But here, if you are going to do that, this is a heavily unionised workforce, and we're dealing here, of course, with members of the trade union. So we're not dealing with people who would not be familiar with trade unions. They would be familiar with the trade union. That's why they have signed up to be members of the union. And that would ordinarily include the fact that they're aware of the collective negotiation circumstances. So whether that happens in 1970, 1960 or 1990 or 2000 and thereafter doesn't really matter. So, my lords, those are my submissions in reply.
Thank you very much indeed. Well, you won't be surprised to hear we will be reserving our judgments. Draft judgments will in due course be circulated to those people who whose names and addresses have been put on the form that was circulated before the hearing. You will be aware of the limited purposes for which the draft judgments are circulated, and therefore the limited further circulation that may be justified. I won't go through those limitations. You'll find them in the Counsel General for the Wales case, which I'm sure is still well known to Counsel. But we will be obviously wanting to be have our attention drawn to any typographical or other minor factual errors, and we will want the parties to, so far as possible, agree the terms of an order giving effect to our judgment, and if they can't agree, to provide short written submissions explaining the nature of the differences, which we will then resolve without a further hearing, in order to be able to issue an order at the same time as we hand down the judgment. Thank you both and those behind you for your assistance in this difficult and interesting case.